Ali Hemani did everything right. That is what the government said about him. He cooperated with federal agents when they came to his family's home. He told the truth. He answered every question. He handed over the firearm he kept in his own house. And when the agents asked how often he used marijuana, he gave them an honest answer. He said he used it about every other day. Ali Hemani thought honesty would protect him. He was wrong. A few months later, the same government he helped indicted him, not for anything he did with a gun, not for any crime at all. They charged him with one single count. They said that because he used marijuana, he was automatically a prohibited person. They said he had no right to the gun in his own home. They said he faced up to 15 years in federal prison and a lifetime of not being allowed to own a gun again. Ali Hemani did everything right, and the government still tried to lock him up for 15 years just for being honest about marijuana. That is the case the United States Supreme Court just decided in a unanimous 9-0 ruling on June 18th, 2026. The case name is United States versus Hemani. Justice Neil Gorsuch wrote the opinion for the court. Every single justice agreed on the outcome. And what they said changes gun law across all 50 states, even if the headlines have not caught up yet. If you own a gun, if you have ever smoked marijuana in any state, if you have ever filled out an ATF form, or if you have ever answered an honest question and watched it turn into a federal case, you need to hear every word of what I am about to say, because this ruling protects you. And it can also be taken from you in the time it takes you to say one wrong word. I want you to stay with me through the whole video, and when I am done, I will give you a step-by-step survival plan you can use tonight. Sharing this video with one gun owner in your family is not a courtesy, it is protection. Subscribe to this channel not because we make entertaining videos, but because the next time the Supreme Court flips the rules, you will not be the last one to find out. Let me set the scene because the story behind this ruling matters as much as the ruling itself. For decades, federal law has contained a section called 18 U.S.C. Section 922 G3. In plain English, that law says it is a crime for any person who is what the federal government calls an unlawful user of a controlled substance to possess a firearm. For most of those decades, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, treated that law as automatic. If you checked a box on a federal firearm form, or if you answered a question from an agent, or if marijuana was found in your home along with a gun, prosecutors could charge you. They did not have to prove you were dangerous. They did not have to prove you were high. They did not have to prove you had ever pointed the gun at anyone. They only had to prove you used marijuana and that you owned a gun. That is the world Ali Hemani lived in. That is the world millions of Americans lived in. 42 states have now legalized marijuana in some form. Medical marijuana is legal in most states. Recreational marijuana is legal in many states. Millions of Americans, law-abiding citizens, hold medical marijuana cards. Millions of Americans, law-abiding citizens, sit down at night and vape or smoke and then go to bed knowing their gun is in the closet. Under the old federal rule, every single one of those Americans was, on paper, a federal criminal. That is the collision we just lived through. On one side, your Second Amendment right to keep a firearm in your home for self-defense. On the other side, the federal government's claim that any marijuana use anywhere, anytime, automatically strips that right from you with no trial, no hearing, no individual proof that you are dangerous. The Supreme Court just told the government it cannot do that anymore. They did it 9-0. They did it unanimously. That detail matters. When a ruling is split, both sides have an argument. When a ruling is 9-0, the entire court has turned and said the same thing. The court said the government's comparison to old founding era habitual drunkard laws fails. They said a 9-0 Supreme Court has now told the federal government that it cannot ban you from owning a gun in your own home just because you admit to using marijuana. And that decision is binding in every single state in the country. And now I have to tell you the part nobody else is going to tell you, because this is where the trapdoor is hidden. Most people watching the news will hear the headline and feel relief. They will think the ruling protects them. It does protect you, but it protects you only if you do not give the protection back. The court did not strike down the entire law. They did not erase 18 USC section 922 G3 from the books. They said this specific prosecution against this specific person with this specific evidence could not stand. They said the federal government cannot disarm a casual marijuana user by relying on the loose language of that statute alone. They left the door open, and they left it open on purpose. The court said clearly that the ruling does not give a free pass to addicts. It does not protect anyone who possesses a gun while actually intoxicated. It does not touch the federal ban on felons owning guns. And the court explicitly said that the government could still come after you under the same law if it brings individualized proof that your drug use actually makes you a danger to yourself or to other people. Justice Alito wrote separately to make that warning louder. He wrote that people who use substances the founders did not regularly use, things like cocaine and heroin, could still be treated differently. Justice Clarence Thomas wrote separately to question the federal government's authority under the Commerce Clause altogether, which is a much bigger bomb that will matter in future gun cases. And Justice Ketanji Jackson wrote separately, joined by Justice Sotomayor, to argue that the court's whole historical testing method may eventually need rethinking. The takeaway for you is simple. Most people think the ruling protects them. They will tell their friend at the range that they are safe now. That is the mistake. That is where people lose. You are safe from automatic prosecution based on use alone. You are not safe if you say the wrong thing, sign the wrong form, agree to the wrong search, or give a confused answer to the wrong officer. This ruling is a shield, and many people will accidentally throw that shield away in the next 12 months, and they will not even realize they did it. Let me explain what the court actually wrote in the plainest language I can. The court leaned on the same test it has been using since the New York State Rifle and Pistol Association versus Bruin decision in 2022. That test, in plain English, says this: once a behavior falls inside the Second Amendment's text, the government has the burden. The government has to point to real historical examples from the time of the founding, laws that were actually on the books back then that justify the modern restriction. The government cannot just say the modern restriction makes sense. The government has to show that something similar was already done in the 1700s and 1800s. That is a very hard test to pass. The government tried to pass it here. They pointed to laws about what they called habitual drunkards from the founding era. They said marijuana users today are like the heavy drinkers of the 1700s. So the modern law fits the same historical pattern. Justice Gorsuch, writing for 9-0, dismantled that argument in 4 moves. First, he said the why of the old laws did not match. Old drunk laws targeted people who could not manage their own affairs, not just people who drank often. Second, he said, the who of the old laws did not match. Old drunk laws were aimed at extreme cases of public dysfunction, not casual wine at dinner. Third, he said, and this is the line every American should remember, heavy drinking was normal at the founding. The court described the farewell dinner where 55 guests worked through 54 bottles of Madeira plus dozens of bottles of wine, porter, and cider just days before the Constitution was signed. If regular drinking had been enough to strip the right to bear arms, half the founders would have lost their muskets. Fourth, he said, the how of the old laws did not match. Founding-era disarmament almost always required some kind of process. A conviction, a hearing before a justice of the peace, a finding of incapacity. The modern federal marijuana rule strips your gun rights automatically the moment drug use begins, with no hearing and no individual finding of danger. That is the part that failed. That is the part that lost. Once you understand that, you understand the whole ruling. But here is the part that has to keep you awake. The court said the federal government has been telling Americans for years that casual marijuana users are not really criminals. Prosecutors were told in 2013 in what is called the Cole Memorandum to generally leave alone state legal marijuana conduct. After oral argument in this very case, the federal government moved certain marijuana products to Schedule 3, the less restrictive category of controlled substances. 42 states now allow some form of marijuana use. More Americans use marijuana than drink alcohol by some recent studies. The court said the federal government cannot, with a straight face, treat the same conduct as harmless on one hand and as a basis for taking your guns on the other. That is the spirit of the 9-0 ruling. That is its heartbeat. The government cannot have it both ways. And do not say yes when an officer asks you a casual question. Do not say yes, I smoked last weekend. Do not say yes, I have a medical marijuana card. Do not say yes, I vape at night to sleep. That is the mistake. That is where people lose. Do not say yes. Watch before you speak. Now let me explain the trapdoor, because this is the moment where the protection disappears. Right now, every person who buys a gun from a federally licensed dealer has to fill out a form called ATF Form 4473. On that form, there is a question 21G, that asks if you are an unlawful user of any controlled substance. Under the old rule, the moment you checked yes, the sale was denied. Under the new rule, after Hemani, the meaning of unlawful user is now in serious dispute. The ATF is now expected to update its guidance. The form is still on the table. The question is still on the form. Many clerks at gun shops across the country still do not know about the 9-0 ruling. Many clerks will still deny your purchase if you mention marijuana. And here is the biggest personal risk I want you to hear. If you lie on the form and say no, when use is later discovered, you could still be charged with a separate crime, making a false statement on a federal firearms form. If you tell the truth on the form because you think the ruling protects you, a clerk may still deny the sale based on outdated training. If a police officer or federal agent asks you in a casual conversation whether you use marijuana and you say yes because you think honesty is now safe, that answer can still be used against you if the government later claims you are a danger under the narrow exception the court left open. Watch before you speak. That is the line. Do not say yes to a casual question. Do not lie on a federal form. Do not volunteer information. Do not waive your rights. The 9-0 ruling is real protection, but only if you protect it. Now let me walk you through the practical survival plan. This is what you do in the real world, starting tonight, no matter what state you live in, whether you use marijuana or not, whether you own a gun or not, because this case will affect how police, prosecutors, and federal agents treat anyone who even comes close to the line. First, stop using casual marijuana language around firearms. If you have a medical marijuana card and you also own a gun, do not announce it. Do not post about it. Do not say it in a room where law enforcement can hear it. Until the ATF rewrites its rules and every clerk is retrained, you are still in a confusion zone. Second, before you fill out an ATF Form 4473, slow down. Read every question. If you are unsure about the unlawful user question, do not guess. Do not check yes because you think the ruling protects you. Do not check no because you think the ruling has no impact. Ask a lawyer in your state. If you cannot reach a lawyer, leave the question blank and ask the dealer to clarify with their compliance officer. Third, never consent to a search of your home, your car, your phone, or your safe without a warrant. The court did not change the search and seizure rules. The 9-0 ruling is about the Second Amendment, not the Fourth Amendment. If an agent wants to look in your closet, say, "I do not consent to a search." Say it calmly, say it clearly, do not resist, do not argue, just remember those words. Fourth, if a federal agent or a local officer begins asking you about marijuana use, drug use, drinking habits, or anything that sounds like it might hit the unlawful user question. Politely say, I would like to speak with a lawyer before answering any more questions. That is not a crime. That is not obstruction. That is your right. Fifth, if you already have a felony conviction, a pending protection order, a domestic violence restraining order, a finding of being a danger to yourself or others, or a past adjudication as an addict, this ruling does not protect you. The court said so. Do not assume. Sixth, never bring marijuana in any form across state lines. Federal law is still federal law. Crossing a state border with a vape pen and a registered firearm is the kind of mistake that becomes a 15-year sentence. Seventh, if you live in a state that still lists marijuana as fully illegal and you also own a firearm, treat yourself as living in the highest risk category. Your state prosecutor may try to charge you under state law even if federal law now bends. State lines do not always follow federal rulings overnight. Eighth, keep your firearms stored safely, separately, and away from any drug paraphernalia, any cannabis product, any rolling papers, any prescription bottle with your name on it for anything a federal agent might call a controlled substance. Mixing items in one drawer is the picture prosecutors love to put in front of a jury. Ninth, if you are the partner of someone who uses marijuana and you own the gun, understand that prosecutors can still try to charge you both. The ruling protects the user under narrow facts. It does not protect bystanders in every scenario. 10th, write down the case name. United States versus Hemani. Write down the date. June 18th, 2026. Write down the vote, 9-0. Write down who wrote the opinion, Justice Gorsuch. Keep that on a piece of paper in your wallet because if you ever find yourself in a courtroom or at a desk in front of a federal agent, the first question that comes out of your mouth should be, I want a lawyer. And the second piece of evidence should be the name of the case that protects you. Now, let me tell you what the state governments are about to do, because the panic the headlines are hinting at is real. State attorneys general are already holding meetings. In marijuana legal states, officials are now wondering whether to update state firearms forms, state background check forms, state concealed carry applications. In marijuana illegal states, prosecutors are looking for ways to keep charging under state law, which often has its own prohibitions tied to controlled substances. Police departments across the country are quietly updating their training. Some are taking the position that the ruling protects casual users entirely. Some are taking the position that the ruling is narrow and applies only to the specific facts of Hemani. In that confusion, you will find opportunity and you will find danger. The opportunity is that if you were wrongly charged with being a prohibited person based only on marijuana use, you now have a powerful 9-0 Supreme Court opinion that you can hand to your lawyer. The danger is that if you walk into a gun store tomorrow bragging about the ruling and announcing your cannabis use to a confused clerk, you may still be turned away, flagged, or worse, reported. Watch before you speak should be your new motto. That is where people lose. Let me also tell you the wider war this ruling is a part of because it is not the last round. Since Bruin in 2022, the court has been taking a torch to federal firearm laws that it considers unsupported by historical tradition. In United States versus Rahimi in 2024, the court kept the ban on guns for people subject to certain domestic violence restraining orders, but it narrowed the historical test slightly. In Wolford versus Lopez in 2026, decided just 1 week after Hemani on June 25, 2026, the court ruled 6-3 to strike down Hawaii's default rule that even licensed concealed carry permit holders could not bring firearms onto private property without the owner's permission. That is your Second Amendment rights on private property. Now, with Hemani, the court has struck another blow at federal overreach, this time 9-0. The wall is moving. If you are a citizen who has been waiting to see whether the Second Amendment still means what it says, this is your confirmation. The wall is moving, but only as long as you do not voluntarily knock it down yourself with a casual answer, a careless form, a handshake waiver, or a signed statement you did not read. That is where people lose. Let me close with the truth you need to walk away with. The court has now spoken, and it has spoken with one voice. In United States versus Hemani, decided June 18th, 2026, in a unanimous 9-0 ruling written by Justice Gorsuch, the Supreme Court of the United States said that the federal government cannot strip you of your right to keep a firearm in your home simply because you admit to using marijuana. That is a real protection. It is binding across all 50 states. It will ripple through the ATF, through state legislatures, through prosecutor offices, through gun counters, through police training, and through your own front door. But that protection lives inside a narrow hallway. Step outside that hallway by signing a form you did not read, by consenting to a search you did not need to consent to, by answering a question you did not need to answer, by saying yes when they asked about marijuana, by writing casual drug use into a chat message an investigator can later read, and the hallway narrows into a trap door. The 9-0 ruling is a shield. You have to be the one who holds it up. Ali Hemani did everything right and still almost lost 15 years of his life. You have the warning he did not. You have the case name, you have the date, you have the vote count, you have the plan. Keep them close. Share this video with one person tonight who owns a gun, who uses marijuana, who fills out a 4473, who knows someone in law enforcement, who has a friend, who thinks the rules will never touch them, because the next person the federal government charges will be the person nobody warned. Do not let that person be you. Do not let that person be anyone you love. The Supreme Court has done its part. Now do yours. Watch before you speak. Do not say yes. Hold on to your rights. And remember this case, United States versus Hemani, 9-0, June 18th, 2026, because the government is already watching who remembers and who forgets.